Hello everyone, I'm Jose Delgado. I'm a corporate commercial attorney. What we're going to cover today is we get often queries from sellers and purchasers of property as to what their rights are under the Consumer Protection Act, or just generally when selling a property. How does this Voetstoots clause apply to me? And also often people ask, what is this cooling off period? How does it apply? Is it applicable to my transaction? So we're going to cover both of those scenarios. Firstly, the cooling off period is a remedy available to, or a right available to a purchaser of a property in terms of the Alienation of Land Act, which deals with all property transactions. So any immovable property transaction in South Africa has to be in writing and has to conform specifically to this piece of legislation. In that act, there is this cooling off period. You have 5 days to withdraw from a contract for a property that you enter into that is valued at less than 250,000. So not a lot of relief for many people, but if you're at the bottom end of the market and you're acquiring a property of that value, then know that you have that remedy available to you. The biggie is the Voetstoots clause. It's an old Roman Dutch principle, and pretty much it says you buy the property as it stands, warts and all. Okay, good stuff, bad stuff. And the seller is not responsible for any defects in the property. The purchaser obviously assumes all of that risk. That, however, is countenanced with the common law principles of latent defects and patent defects. So patent defect is something you can see, and if you enter into the contract, pretty much if you are unhappy with a huge crack in the wall or something that's not to your liking after the fact, you pretty much have no claim because it's something you could see, and the Voetstoots clause would cover that for you, for the seller rather, if you're a seller. In the event that it's a latent defect, which is something you cannot see, okay, and under the Voetstoots clause, the seller will not get protection if they were aware of the latent defect. Right, so Voetstoots clause will protect the seller, and the purchaser will have no remedy available to them if the seller was unaware that there was a latent defect. However, if there's a latent defect that the seller is aware of, the Voetstoots clause will not protect them, because basically that's misrepresentation. So there you have it. Those are the two positions. Cooling off, you have 5 days if you're buying a very, very low-end property, or if you're a seller, make sure you get protection if you are selling the property under the Voetstoots clause. If there are defects that are not visible, make sure to bring them to the attention of your agent, bring them to the attention of the purchaser. If you're a purchaser, obviously do your homework, get as much information, ask the questions, ask the agent the information, and if they then make representations that later on you can rely on if you've been misled or you've not been correctly informed. Okay, so just be sure to check those positions when you're buying or selling a property.